All right, I am Phil Weiser, Attorney General here in Colorado, longtime participant in these proceedings and the co-author of the first two editions of Digital Crossroads. Today we're going to talk about the third edition. I strongly recommend the book to you all because a lot has changed in the last, John, 12 years? 12 years since our second edition came out. When John and I sought out to write the first one, the goal was so that in rooms like this, in places where people were struggling with telecommunications law and policy, there was a good place to start. This is a very hard field to get your arms around, and when John and I started, it was like, talk to this person, read these 15 papers, and you'll get the hang of it eventually. We thought, there's got to be a better way, and so the first edition was born. The third edition comes at a very interesting time for telecommunications law and policy, and I want to welcome the, I'm not sure what we call it, replacement player here, Howard Shelanski, who came in to work with John on the third edition, along with John, who has been on all three, and just have a conversation about where we are in the state of U.S. telecommunications law and policy. And I guess I will start with a little bit of the elephant in the room. There's an argument one could make that telecommunications law and policy in general, and maybe the FCC in particular, is less relevant today, is less significant and important than when John and I and Howard got into this world in 1996, 30 years ago, and we were talking about a very changing and different world, from monopoly providers to convergence and competition. So I guess I'll start with the question, why and how should we think about telecommunications law as still relevant, and what's the next sort of chapter going to look like that may be different than the last?
So I can remember pretty well when I first reached out to you, Phil, about this project, and it was February of 2003, which seems like a very long time ago now. The best and brightest minds in America at that point were focusing on what's the best regulatory solution to allowing people to have multiple options for circuit switch landline telephone service. And we, early drafts devoted, I think, something like 4 chapters to that question. And it's quaint now to look back on those times. Obviously, a lot of the regulatory disputes that we addressed in the first edition and even the second edition have been overtaken by events, and those events can be summed up in one word, which is competition. We have much more competition in the telecommunications space than we did when we set out to write this book, and as competition evolves, the need for competition-oriented regulation obviously diminishes. But there's an upside to this hindsight from the perspective of this book, which is we learned a lot of lessons from the Telecommunications Act of 1996 and its implementation. And those lessons have a lot to teach us about analogous proposals to regulate big tech companies. And so we devoted a new chapter in our book to the lessons from the 96 Act for proposals to impose common carrier style regulations on tech companies. Before I pass this over to Howard, I do want to make one plug for telecommunications policy, because despite the fact that we no longer look for options for local circuit switch landline telephones, there are a lot of continuing controversies in the telecommunications space, and they range from spectrum policy, which remains as vibrant and controversial as ever, to universal service, digital equity style issues. And so the book continues to address all of these current controversies in the telecommunications space. But I would say certainly a couple of the chapters are more retrospective than prospective. The chapter 2, for example, about wireline telecommunications regulation has become largely a history chapter.
By the way, when we were writing the first edition, we were having that problem in real time and ended up with incredible, thoughtful work that John had done on TELRIC in an appendix because it
Telric.
felt a lot less
How many
relevant.
people in this room know the term Telric?
That's a pretty good, yeah, pretty good showing. Howard, you joined this project knowing that the world was changing. What would you add to John's answer?
No, I mean, I agree with John. I think that telecommunications policy as a field that is a central focus of legislatures, state public utility commissions, and something that occupied a lot of political and frankly judicial time has certainly shrunk. But you can unbundle, if you will, all of the
Pun
issues.
intended.
No, fully intended. You can unbundle the complex of issues that were at stake when Phil and John wrote the first edition, and say there's several of those that remain very important issues. Spectrum policy remains extremely important. Equitable access remains particularly important. But largely, I agree with John that one of the most important things we can do now is to look at the actual lived experience of 30 years of the 96 Act and the regulation that was born out of it, and see what we learned from it as we think about some of the new technologies that we're living with today and that are coming down the pike.
Let me start with the analogies to big tech, and I will come clean here. I am leading the state coalition in a case against Google where the question is what remedies for monopolization are appropriate. One of the remedies that is in play is a data sharing remedy. To what extent are lessons from past telecom regulatory chapters applicable to the antitrust remedies being considered in Google?
I think it's important to start from the economics because the features, the economic characteristics that made telephone companies monopolists back in the 20th century were a combination of network effects, scale economies, and to some extent switching costs. And the Telecommunications Act of 1996 was designed to address all three of those economic characteristics as a means of inviting new competition into the market. So to address switching costs, there was number portability. To address network effects, there were expanded interconnection obligations. And to address scale economies, there were what we called UNIs. These were unbundled network elements. They were essentially facilities leasing obligations that were imposed on the telephone monopolists. And so we had this whole regulatory structure that was designed to open markets by tackling each of those economic concerns. The same economic concerns are present today in the debates about big tech. You see concerns about interoperability. You see connections about data scale, winner-take-all theories about the big tech markets where data is a crucial input. You see concerns about switching costs as well. And so in legislation and in antitrust remedy proceedings, you see analogs to the regulatory proposals that were adopted in the 96 Act. So instead of interconnection, you have interoperability requirements. Instead of scale economy, instead of facilities leasing obligations, you have data sharing obligations. And instead of number portability, you have data portability. And in our final chapter, we address each of those proposals through the lens of what we learned from the 96 Act. We don't purport to draw firm conclusions, but we do identify the costs as well as the benefits of those forms of regulatory intervention and what they mean in particular cases.
Yeah, I mean, I agree completely. I think the only thing I would add to it is I think it is worth asking a question whether in thinking about the imposition of all of the interoperability, data sharing, and other remedies, for example, in the federal, in the DOJ's Google search case and some of the other cases that are pending, whether we are here in 2026 sort of at the same kind of technological inflection point that we were in 2003, are some of those issues going to be overcome by some of the new kinds of technologies, AI platforms, LLMs coming into the marketplace? And will some of these remedies be a little bit outdated by the time that they're really getting traction? But I think that the remedies themselves are variants on some of the things that we learned and that were indeed very effective in creating the kinds of local telephone competition, for example, through which wireless was able to thrive and really make the old circuit switch debates seem rather quaint.
I think it's fair to say that we're a little critical of the 96 Act. And it's easy for us to say that in retrospect. There were some features of it, like number portability, that were obviously good ideas. But there were others that produced regulatory churn for about 10 years before people woke up to the fact that competition wasn't going to come from regulatory intervention. It was going to come from technological alternatives to circuit switch, to wireline telephone service, including mobile and broadband. And those were developments that Congress and the FCC simply didn't fully appreciate back in the late 90s.
Well, let me offer a defense of the 96 Act along the following lines. If you thought about the 1996 Act in purpose and effect having three complementary goals: wireline competition, wireless competition, and the emergence of internet and broadband platforms, if the Act helped the latter two, and they succeeded wildly, and the first one fell on its face, if you're playing baseball, it's not a bad batting average.
I mean, except that I don't think that the focus of the 96 Act was on broadband. I think Congress didn't, in fact, you know that because we've had decades worth of disputes about whether broadband internet access is a Title I or a Title II service. If Congress had been focusing on that, we would have had an answer.
Although I think you could say that the framework that the Act put in place allowed for the emergence of broadband competition, and you could also say that prior laws, program access laws, and also spectrum laws were trying to encourage more forms of competition. And so I think even if precisely they weren't thinking about it, I'll give them some credit for directionally trying to move the environment. And so I think when you grade the 96 Act, it's very easy to focus on the wireline competition, particularly like all the time spent on the unbundled network element platform, take one example, and say, boy, wasn't that all the waste? But if you pull the lens back and say, of all the things they tried to accomplish, they did help accomplish some important things.
Yeah, look, I think that's clear. That's clearly true. But I think even with circuit switch, the Act did two incredibly important things: mandatory local interconnection and preemption of state monopolies. I think that was incredibly important because it basically said the field is now open for competition. Did it go a little bit too far in some of the unbundling requirements, and then were those taken too far in their regulatory implementation for things like, UNIP and best available, hypothetical networks? Sure, but those were efforts to try to jumpstart what was still viewed at the time as the most important sort of local access. But I think certainly there was a major vibe shift and some important principles put in place that paid off later with broadband.
Yeah, this is during the time when people still referred to the internet as the information superhighway, and so I think the aspiration was right on. Everyone understood that it was important to get computers connected because progress would follow from that. But at the same time, the legislation was to some extent drafted by competing lobbyists for the Bell companies and for AT&T and MCI, which were the legacy long-distance companies. And their interests were diametrically opposed and short-term. It was all about the Bells trying to get into the long-distance market and the long-distance carriers trying to get into the local market. And so that's why 90% of the Telecommunications Act of 1996 looks like it was written for an environment where, for the foreseeable future, all this computer communication was going to be done via dial-up internet as opposed to broadband.
You mentioned how important spectrum policy is. 3 points in the book that I'll just note and then feel free to comment on. One, the challenge where the FCC was authorizing spectrum that was going to be used in ways that had the potential to interrupt airplane communications that the FAA wanted to protect.
C-band.
C-band. Second, to use the acronym, the EBS, which was a band of spectrum that was given to universities, but then quickly it was leased to private entities. The FCC basically, I think, acknowledged or called that experiment amiss and just gave it to private wireless broadband companies. And then third, you make the statement at the end of the chapter, the FCC needs to do more to define interference rights, which obviously is related to the first case study I mentioned. Any thoughts on the future of spectrum policy that are top of mind?
First thing I want to say is, first thing I want to do is give a shout out to Phil, because of all the chapters in this book that have changed the least, I'd say probably is chapter 3, which Phil originally drafted about 20 years ago. A lot of the insights in the chapter draw directly on Phil. And also, is Dale Hatfield in the room?
Yes, he is.
So, hey, Dale. You know, a conference with Dale in the audience cannot go by without someone offering praise for Dale and then Dale doing this. So Dale and Phil were pioneers in spectrum policy, as was Evan Querrell, who's
here too,
right behind Dale over there. Those two guys get a lot of credit for where we are. Was that?
Yes, John Williams.
Yes. Okay. He's not in the room, though. And Phil and Dale co-authored a number of articles on spectrum policy, which were a really seminal scholarship in the field. And so chapter 3, to the extent you like it, give the credit to Phil. We did update it. We did talk about the C-band controversy and the EBS controversies. And we, to some extent, talk about recent developments to try to address interference issues on a more systematic level than the FCC has historically done. I don't know how much time we have to get into this, and it's incredibly complicated. But the upshot is that traditionally, the FCC would give broadcasters the right to use their frequencies as they wished, and anyone who interfered with the ability of somebody with a cheap transistor radio to receive signals over the air would have their transmitter suppressed. And the result of that was no interference for the broadcasters, but a lot of opportunity costs in the form of foregone technological innovations that could have made better use of some of the available spectrum. And Ronald Coase anticipated all this back in the 50s when he wrote an article just entitled The Federal Communications Commission about how uneconomic the FCC's view of spectrum policy was in that time. And one of his key insights was that interference policy needs to focus on not suppressing interference entirely, but finding the right level of interference. There can be too much interference, but there can equally be too little interference. And the FCC has not systematically addressed how to implement that insight, and it's a very tough task because these interference issues arise in many different ways. The C-band controversy is a great example of that. And it's hard for the FCC to anticipate in advance what rules to impose to permit the most efficient outcomes in the mediation of spectrum disputes.
Well, let's talk about that C-band, because there the FCC, to its credit, said if airports are keeping the most outdated, antiquated equipment that can't handle any possible interference, they need to upgrade their equipment. However, the FAA had a different view, and so this was a very interesting case study where the FAA was able to make some announcement right before Christmas that they were going to shut down flights, and that got people's attention.
Yeah, so I mean, it became a political dispute. So AT&T, so the FCC says that. The FCC says we're going to, this spectrum, which is 200 megahertz distant from the spectrum used by radio altimeters.
That would be called a guard band, right? They left the guard band in place.
It's a big one, too. But apparently, some older altimeters used in some planes and some helicopters could suffer some interference from the use of the upper C-band, or what at the time was called the upper C-band. And the FCC said, look, we're not in the business of suppressing any technology that may cause interference to old, insensitive devices. And so airline industry, you really need to get your act together and find out which aircraft rely on these older altimeters and then upgrade accordingly so that we can have greater broadband, mobile broadband resources in America to power our new information economy. And the airline industry didn't really pay a lot of attention to that. So AT&T and Verizon spent a combination of, I think, something like $80 billion on C-band spectrum. And they were all set to turn on the transmitters on their towers at the end of 2021. The airline industry goes to the FAA and says, this is insane and outrageous. You need to do something about this. And it became a political football. So the FAA basically threatened to cancel a bunch of flights around Christmas. And everybody knows that that's politically unsustainable. And to avoid the blowback, AT&T and Verizon had to enter into some sort of ad hoc deal with the administration and with the airline industry to sort of muddle through the problem. It became ugly and political because there wasn't a single voice speaking for the executive branch. By the way, for anyone who wants to know more about this, I see Harold Feld is here. He has written one of the funniest accounts of this dispute on his blog, Wet Machine, correct? Yeah. So read that. It's very entertaining.
Well, let me follow up because you made this point. The FCC at that point was an independent agency, the FAA part of DOT. The FCC, like the FTC, I think can no longer take solace in the Humphreys executive decision that it can operate truly independent of the executive branch. Should we have the FCC separate from the executive branch, or should it be merged into, say, NTIA to create an executive branch agency that might have made the coordination with the FAA easier?
I mean, I think there's a strong case for that, the C-band controversy aside, right? I mean, at this point, if you look at the range of issues that the FCC is working on with regard to spectrum, and probably the things that are the really important work that a lot of us think the FTC does and should be doing, it seems to me like there's a very good case for merging NTIA and the FCC together and getting it to have a much more narrowed regulatory remit that focuses on those issues. And the C-band controversy highlights that there are probably coordination issues from which integration into the executive branch would help. There's a whole another set of issues that the FCC still engages in, and if it were truly an independent agency, we might have some trepidation about integrating those into the executive branch. But after Humphrey's executor, it's really a question of mechanism of executive branch control and where something sits on an org chart than really meaningful independence. So I might be in favor of opting for those coordination benefits and integrating the the FCC, excuse me.
That could have been a Freudian slip because the same could be said about the FTC and the DOJ. Let me ask about two mergers, one that you explicitly talk about and one that I think is teed up by the conversation in the book about retransmission consent arrangements. The first is Sprint T-Mobile, which in antitrust terms is a 4-to-3 merger. You, I think it's fair to say, are quite critical that that merger was allowed. Do you want to share any thoughts on that?
Well, I don't think we take the position that the merger shouldn't have been approved. And it's a mixed bag for consumers because there were real spectrum synergies to be drawn from that 4-to-3 merger. If you're a T-Mobile customer and have been for some time, you will have noticed that your service is much, much better than it was before. So in the high end of the consumer marketplace, you see more competition than you did before. It used to be that AT&T and Verizon occupied that space, and now they face real competition from T-Mobile, which can credibly claim to be technologically on a par with or superior to those other networks. The main concern about that merger is about prepaid customers, budget-conscious customers generally. That was a market in which T-Mobile and Sprint were next closest competitors. And the theory under which the US government writ large ultimately approved the merger was that dish networks would enter the market and become a facilities-based provider so that it wasn't really a 4-to-3 merger. That has turned out to be a fanciful hope. And so there are certainly some customers for whom that transaction was detrimental. So on that level, I think, yes, we can criticize the merger, but we shouldn't lose sight that there are benefits for very, very significant swaths of the market.
The next merger I'll mention is currently pending. Nexstar and Tegna are trying to merge, and the state AG coalition, bipartisan coalition, of which I am a part, is seeking to stop that merger. That would be in Colorado, Denver, for example, a 4-to-3 merger that would give the two companies 57% of the market of local broadcast TV stations, which has long been accepted as a market. There are a few questions here. You talk in the book about online streaming as coming up. The FCC has long both protected and advanced the goal of localism and local news, which these 4 players in Colorado, for example, are the sole providers of. And obviously, retransmission consent fees have been going up steadily over the last several years. This merger threatens that trend to continue. As you think about that marketplace and this merger challenge, do you guys have any thoughts you want to share?
Yeah, I mean, what I would say is, one can take the view that conventional broadcast doesn't matter and that the localism concerns that motivated the original ownership caps and original broadcast ownership policy are outdated. I think there's a strong argument that that's not the case. Congress certainly hasn't decided that that's the case. So, I do think that this merger on its face raises some concerns. I think it's not coincidental that we've seen the media ownership caps be lifted by the FCC while, all of the debate over this merger is going on. But this is a transaction that I don't think even would have been considered as plausible, 20 years ago. And I think that it's if we agree or believe that this is a separate market and that there are these local products that will not otherwise be in the market, and I don't believe that streaming provides them in the way that local broadcasters do, this is a merger worthy of serious scrutiny.
This is a merger that's of even greater interest to my daughter than to me because she is in the broadcasting industry. She's actually a reporter. And suffice it to say that the broadcast industry has been in a state of decline for a long time. And it is unclear to me what the right answer is in cases where the market is subject to real-time shifts of the sort that we're seeing with broadcasting now.
Antitrust does have a clear answer. If there's harm within at least 2 years, you prevent the harm. I recognize that is controversial and can look foolhardy in retrospect. For example, the MCI WorldCom merger that was going to happen with Sprint was stopped in part because of fears of harms to the long-distance market. So obviously, we look back and say, they shouldn't have been worrying about it. It was a ephemeral point in time. The response is, for some non-trivial period of time, I think it might be non-transitory is what the merger guidelines say, but whatever, the harm could have been prevented, and the theory is it should be prevented.
So you were in the antitrust division when Sprint, when...
I was not for that one. I was there for the earlier one, MCI WorldCom merged, and then MCI WorldCom wanted to merge to Sprint. I was on the outside looking in. There was a second concern in that market that stands up better in hindsight, which is the internet backbone market and the worries about concentration in that market, because the earlier merger, MCI WorldCom had to spin off Internet MCI to Cable and Wireless. That is a poster child in a failure to handle merger remedies. It ended up with a breach of contract lawsuit and Cable and Wireless basically having no business left. So the competition that was attempted to be preserved by the divestiture totally failed. All the customers ended up at that point, the merged company, which was UUNet WorldCom, And so that was a second reason to stop that merger.
But it was the best reason to stop the merger,
Yes.
because in fact, that attention to the internet backbone market has given us what we have today, which is an unregulated marketplace for peering, transit, and other forms of interconnection among IP networks. And we wouldn't have that if we had allowed undue concentration in the internet backbone market in the early days.
And the chapter that talks about the internet backbone is a great explanation of how that market works. I really want to get to Dale Hatfield's question, but I'll ask you one more before I turn to Dale for a question, then anyone else in the audience. You mentioned, John, before about digital equity, which for those familiar with the BEAD program know is a goal, which is how do we enable adequate and effective broadband access for all. One of the big topics of debate is how much fiber should be the goal, which was stated as the goal by President Biden, President Trump. They've changed the approach, focusing in a way that is less fiber-centric. What's your view of that issue in general, and maybe that specific policy judgment?
So I'm in violent agreement with Scott Walston's early article on this issue, an op-ed piece from a few years ago, which which was entitled something like "Too Much Fiber in the Broadband Diet." And it opened by saying, we all know what happens when there's too much fiber in the diet, and it isn't pretty. And that was, I think that there was almost a fetishistic attachment to fiber in the Biden administration as a solution to universal service. And this is one of the rare moments in which I find myself sort of agreeing with the Trump administration's de-emphasis on fiber. I mean, particularly in an environment where LEO satellites are just completely changing the game. It seems very short-sighted to me to be building to focus on this extremely capital-intensive solution for rural environments where it really doesn't make sense from a cost-benefit perspective. This is not to say that fiber isn't the right solution in a lot of areas, and it is. But there was just a kind of lack of sensitivity to the costs and benefits of fiber and in more remote areas.
Dale, care to ask your question? I'll repeat the question, unless there's a microphone, which apparently there is.
For the past year, half, 2 years, I've been a really heavy user of AI for two reasons. One, because it helps my research and spectrum management, but I also wanted to learn more about AI from the inside, so I understood better what its limitations and advantages were. But in that 2 years or so, this has changed. The market has changed so fast. I don't see how we're going to be able to put in the right sorts of regulation, policy choices in something that's changing so darn fast. The probability of getting something wrong is, well, I've made my point. It's changing to them. How are you going to handle the really rapid change?
I'm just going to repeat it just in case it didn't get through. The institutional mechanisms to oversee fast-changing technologies is a hard one for any public policymaker, because before you can get the right rules for today's technology, you have a new technology tomorrow. I think that's the generous explanation, John, for the BEAD answer you gave, which is when the idea of a broadband stimulus and broadband access plan was happening, I think LEOs weren't viewed with the same credibility that they are today.
I remember we talked about LEOs at some length at this conference 2 years ago, and there were a number of people in the audience who were unfamiliar with the very concept of LEOs, who thought that there would be the same latency that you have with geosynchronous satellites, and weren't aware that there were these new fleets of satellites that are capable of low latency transmission. So just in the last 2 years, we've seen very, very important progress.
So that's just one issue in universal service policy where there was time and ability to adjust. But Dale says that you're thinking about any regulatory oversight of AI, and it moves quickly. that's quite a conundrum from the institutional side.
Yeah, I mean, I think it's a huge conundrum from the institutional side, but first let's break apart different kinds of regulation that people are talking about with regard to AI. I mean, there's a whole question of safety regulation and certain uses of AI that people are concerned about. I want to put those aside. If what we're talking about is competition regulation, so what we're really interested in is making sure that, Dale, when you go, and you and I have talked about this, you cross-reference different LLMs in the results they give you, the answers they give you. If you want to keep having those competing models and access to those competing models, what can we do to make sure that the environment at least remains reasonably competitive and doesn't, for some reason, tip for one market or the other? And I think that there is a really hard question about what regulation or whether regulation is needed. Are we looking at a universe where the mutual interest of the competing LLMs in exchanging data and allowing users, agents to cross, underlying applications that the owners of those LLMs might have and the different respective data stores and histories that those different AI platforms have, is there enough mutual interest that they'll be like the internet backbone for peering and transit and come up with commercial sort of solutions? Or is it possible that, Google owning Gemini will know that it has, certain kinds of data in email, in video, in all kinds of other things that people need and attempt to foreclose, and when we need interoperability, interconnection, data sharing regulation? I think we don't know the answer to that until we really understand what the use cases are, how consumers are using these things, what the technology is for getting access, and what the actual commercial interests of the parties are. So there is a real danger as these technologies are developing so fast and the way consumers are using them, of putting in place a regulation that is either unnecessary or, in fact, potentially harmful. I do think right now there probably are certain kinds of data sharing principles or regulation that could be put in place that probably would not bias the way that the use cases develop. Those things may become unnecessary, but I'm not sure that they necessarily do harm. So I think there is a case for thinking about certain of the lessons that we've learned from the 1996 Act about the regulatory techniques that work and seeing if they are applicable in AI. But I agree, it's something to approach, I think, carefully, because the way we are using these technologies and the way that they work in 6 months will be different from the way they are now. The last panel suggested that there may be ways that quantum computing can start to power or converge with AI in ways that will change things yet further. So I do think that it is an important regulatory challenge, but not an impossible one, and that certain of the principles probably are applicable, even as fast-changing as AI is today.
Time for another question. Yes. I can repeat the question too if you.
Okay. I'm Jeff Baumgartner with Light Reading. Thank you. I just had maybe a follow-up on the whole satellite topic, right? And what we're talking about the role with BEAD and everything, but with satellite kind of taking up a lot of oxygen right now, and things are really moving quickly, and I was just wondering, are regulators keeping up, with the pace right now, or can they even keep up? And kind of tied in, I mean, what do you think is like the right balance, kind of given that you want things to continue to move forward, but do so without hindering, the progress and innovation that they're pursuing?
So, so satellite is a solution for many of the markets that were traditionally the focus of the FCC's universal service efforts. So when I think of the digital divide in this country, I think of two different divides. One is between urban and rural, and that's been the focus of the FCC's high-cost program. The other is between rich and poor, and that's been the focus of Lifeline and the now discontinued Affordable connectivity program. LEO, I think, will over time solve the first of those concerns. There will be very few places in America where it will remain the case that you have no broadband internet options. You'll have good broadband internet options. They may be more expensive than the options in urban areas, but that's part of what comes with the territory of living in a more rural area. Everyone is going to be connected because we now have this solution that can beam signals into people's houses in remote areas. So we should be grateful for that, but as you know, there are serious questions about whether LEO is going to be a competitive force, a major competitive force in urbanized areas, for example. And there are questions about whether it will scale properly, what the price point will be, who's going to be the typical user in urban areas of that technology. And I think the jury's still out on those.
I'll pick up the broader point you had back to the institutional side. When I reviewed the Federal Trade Commission for President Obama in the transition in 2008, there were no technologists at the Federal Trade Commission. And one of our strong recommendations is that needed to change. It has changed. There's now a whole technology function of the Federal Trade Commission. Dale, of course, led this effort at the FCC, which has a tradition of technologists, and helped to broaden what type of technologists worked at the FCC. At my office, Colorado Attorney General's office, we've hired our first chief technology officer to help us as we're dealing with issues like AI. So I think the point about government needing to have more awareness, more knowledge, more insights around technological change is absolutely right. And we're seeing that movement, probably not as quick as would be helpful, but it is absolutely underway.
There's a separate question also about competition policy in the LEO space. So right now, Starlink obviously is the dominant player. Amazon LEO, I'm looking over at the Amazon people here in the crowd, they are nipping at the heels of Starlink. On the other hand, I think there is a potential monopoly in launch services. I mean, there's an actual monopoly in the case of commercial launch services in the form of SpaceX. And so the regulatory problems that may arise in the LEO ecosystem are likely to fall outside the scope of the FCC, I think, because the biggest concern is really about finding ways to efficiently launch competing providers of LEO services.
Yeah, and I'll just add one other vertical concern. As LEOs start to sign up agreements with mobile phone providers to provide satellite mobile, to the extent that those start to take on an exclusive and foreclosing aspect, there would be an antitrust issue there.
Well, thank you all for being a great audience. Thank you, Scott and TPI, for the chance for this reunion.
And thank you, Phil, for agreeing to be a moderator who is orders of magnitude better known than the panelists.
I think Scott will tell us what's next, or someone will. Let's give him a hand of applause. That was fun. Thank you.
Thanks, that was great. Actually, to tell you what's next is that John can't leave the stage because he's got to moderate the next panel.
Yeah, so what's next is the Supreme Court.
Two panelists, correct? Three. Is it three?
Three.